Okay, good morning everyone and welcome to our DC Excellence webinar. Today we're going to be focusing on what a lot of us are seeing at the moment, DC to DC transfers. I think certainly in our team we've seen a huge increase in these over recent years, and we think this is a trend that is only set to continue with more and more of our clients are looking at consolidation, and certainly that's the direction of travel from the government as well. So the purpose of today's webinar is really to share our experience of working on those projects with you, looking at not illegal issues that come up, but also sharing some real practical insights into what the market looks like, the master trust market, and also things to look out for when you're embarking on these kind of projects. So we're going to be guided through the presentation today by our two speakers. So our first speaker is Hannah Beecham, who's a principal associate in the team here at Gowling. Hannah and I work on a lot of these DC to DC transfer projects together, both from the perspective of employers, but also trustees, transfers from occupational schemes, but also looking at employers looking to move from GPPs actually as well to the master trust market. Hannah's joined by Shabnam Islam today, who's head of DC provider relations at Hymans. So Shabnam is the expert in all things master trust related and is really used to seeing these projects implemented from start to finish, advising both employers and trustees on all aspects. So has some real practical experience that she's going to share with you today. So before we move on to the presentation, just a couple of housekeeping items I just wanted to mention, please. If you have any questions, there's a Q&A box at the bottom of your screen. You can type any questions into there, please, and we'll do our best to answer those at the end of the presentation. And then once you log off at the end of the webinar, there's a feedback form. And as always, we'd be really grateful for any feedback that you might have on the presentation. So without further ado, I'm going to hand over to Hannah. Right, thanks, Hannah.
Thanks, Jo. Just moving on through the slides. Okay, so I thought I would just start before we dive into the presentation with a brief bit of background, just to recap for a lot of people on the call. I know just talking about what is a master trust and how they're regulated. And I think it's fair to say that master trusts are not a new thing as a legal model. They've been around for a long time now, most commonly seen, I think, in industry-wide schemes where you might have a lot of unconnected employers participating in a single pension scheme. DC master trusts, though, have proliferated over the last 10 years or so, and I think the main catalyst for that has been the introduction of automatic enrolment as a requirement for employers, meaning that more and more employers have needed to establish workplace DC pension schemes. And I know Shabnam's going to touch in a minute on some of the other reasons why employers and trustees might be looking to move to master trusts. From a legal perspective, this proliferation of the number of DC master trusts over the last 10 years or so led to concerns about how master trusts are regulated and how we as a pensions industry ensure that master trusts remain a safe and high quality place for people to have their pension savings. So this led in 2017 to the Pension Schemes Act 2017, which is legislation introducing a regulatory framework for master trusts. That legislation introduced a statutory definition of a master trust, and any scheme that meets that definition has had to apply for authorisation from the pensions regulator to operate as an authorised master trust. And now it's actually it's illegal. It's subject to a civil penalty if you operate a master trust that has not been authorised by the pensions regulator. In order to get authorised, master trusts have to demonstrate a number of things to the pensions regulator. The process is quite stringent. I know we've been through it with a couple of our clients that are master trusts, and there's a lot of information that has to be provided. So there are assurances around the quality of the master trusts, the people that are running it, and whether they are fit and proper persons to be running a master trust. And there's also quite a lot around the administration that sits behind the master trust, and also continuity planning for if the master trust were to close down at any point in the future. So with all of that in place, the market for master trusts, and Shabnam again, we'll talk about this in a minute, has changed and continues to develop. But I think the authorisation of master trusts has also meant that a lot of employers and trustees are now looking at master trusts as a good option for their future pension provision. So I'll pass over now to Shabna, who's going to talk a little bit about what the DC market looks like at present.
Thanks, Hannah. So on this slide, I've got the current DC marketplace and what that's looking like. We have 36 authorised master trusts with a total of £110 billion of assets under management. Now, that's overtaken the single employer trust arrangements in the last year, which is running at around £71 billion. So master trusts have gained quite significantly from that move away from single employer trust. Now that shift or trend is continuing to grow. We haven't seen a peak of activity yet. We expect it to continue for a number of years, especially with a push from the regulators, in particular targeting some of those smaller schemes, those schemes smaller than £100 million. The other area is contract-based arrangements or GPPs. They are remaining relatively flat. We are seeing some movement, so some of those moving towards master trust. Then looking into the future, so where do we expect the market to be in, say, 10 years' time? So I expect the number of master trusts to reduce, and that's via consolidation of providers to around 15 to 20 providers. We expect the growth in assets under management to continue, still with some further shift from single employer trust arrangements, but also through investment growth and regular contributions. And with single employer trust arrangements, we expect that to reduce, and the schemes that remain as single employer trusts are those for some of the largest employers, is what we expect. For contract-based arrangements, again, just remaining relatively flat. Again, continue to see some movement towards master trust, but some of those movements offset by new arrangements where master trust may not fit for that employer. So those are the trends that we're seeing in the market, but what's driving that move to a master trust? So on this next slide, I've got some of the common reasons for employers and trustees. So there's lower costs and charges. The running cost for an employer are typically lower in a master trust, typically also lower charges for members. The market is very competitive and pricing continues to be pushed downwards. We're also seeing improved member experience. So master trusts, they invest really heavily into their proposition, their admin functions, their communications, their digital tools such as mobile apps, and they offer a very smooth and well-considered member journey over the whole saving phase through and into retirement. There's enhanced governance. That's through a dedicated and independent master trust board with scheme strategists and huge teams to support them. Now, in some cases, the move is part of a wider strategy. For example, that could be that if you've got a DB section of a hybrid scheme, that's part of its end game planning is looking to buy out its DB benefits with an insurer. And part of that plan is to wind up the trust. Therefore, there's a need to transition the DC section members, and typically that's to a master trust. Now, master trusts do offer, I believe, a future-proofed arrangement. It's a product where the providers continually invest heavily to offer solutions that members need and want, not just now, but into the long-term future. There's some of the things in the last couple of years that have stood out for me in terms of master trust being really future-proofed is that significant ESG integration into their default investment funds, the use of digital to enhance members' experience, as well as integrating wider financial wellbeing solutions as part of the member journey. Now, overall, this is leading to better outcomes for members, and not just from a trustee perspective, but also employer perspective. Hannah's going to take you through some of the key responsibilities for employers and trustees.
Great, thanks, Shabna. So in this next bit of the webinar, we wanted to talk you through the key stages of a master trust transaction. And before we get into the detail of that, I just wanted to take a step back and look at it from a legal perspective, because I think one of the key points from a legal perspective in relation to a master trust transaction is that actually there are two separate transactions happening typically. And so I've set this out on the slide here as a two-stage process. The first stage is the employer's change of its provider for its future service pension benefits for its current employees. And that is a change in relation to future service benefits. And so legally speaking, that is primarily an employer decision. And the role of the trustees, and anyone who's been through any kind of scheme closure exercise will have heard this previously, the role of the trustees in pension scheme is primarily to look after accrued rights, so what has already been built up. And the role of the trustees in relation to deciding what benefits current employees should get in the future is somewhat limited. And so this first stage of a master trust transaction, you might think it isn't particularly a trustee issue or concern. Having said that, the second stage of a master trust transaction, which is the transfer of the pots of savings that members have already built up in the existing pension scheme over to the provider, is very much a trustee issue and concern. There are a few reasons for this. Pensions legislation sets out a lot of requirements around trustees and transfers of accrued pots if that is happening without member consent, which is typically what happens on a master trust transfer. So there are responsibilities for the trustees to investigate and do due diligence on the receiving scheme to make sure that it is, for example, an authorised master trust that can accept those transfers without member consent. The trust deed and rules for most occupational pension schemes will also typically give the power to transfer accrued benefits to the trustees or to the trustees and employer jointly. So employers looking to move their existing pension scheme, the accrued benefits, to a master trust provider are likely to need trustee cooperation and consent to that stage of the process. And so what we find in practice is that while legally you might say this is a two-stage process where stage one is all about future service benefits and so is an employer issue, and stage two is more of a trustee concern, in practice, most employers would not want to embark upon that first stage of the process until they're sure that the trustees are also on board with the future plan to transfer the accrued pots, because it can be very awkward, to say the least, if you get a situation where an employer has decided and communicated with its staff about moving their future pension savings, but then finds that the trustee is uncomfortable transferring the pots that members have already built up into that new provider scheme. And I think we'll talk a little bit more in a minute about how you manage that in practice, around making sure that the trustees and the employers are well engaged in provider selection and the process. Just before we move on to that, I also just wanted to touch briefly on the role of the trustee and the trustee considerations in deciding whether or not it's appropriate to use their bulk transfer power to transfer benefits into a master trust. And I think one of the points which comes up on frequently in practice is for the trustee to understand whether, in order to go ahead with a master trust transfer, they need to be absolutely comfortable with every aspect of a master trust and its provision, whether they need to be satisfied that everything in the master trust is as good as or better than their existing scheme. And my view is that that's not the case, that actually in practice trustees can look at a decision whether to move to a master trust in the whole. They can weigh up a number of different considerations, including the impact on the members and looking at the transaction more holistically in deciding whether or not to go ahead. So I'll pass back to Shabnam now to talk about the key phases of a typical project from her perspective.
Thanks, Hannah. So here's the typical framework, all the phases for the Master Trust transition project. And the key point here is to emphasise Hannah's point that whilst the asset transition is at the end of the project, it is reliant on the trustees to approve a bulk transfer. So therefore, it's really important that the trustees are involved in the project from the start. So step one at the objective setting stage. So really working alongside the employer to determine what features the trustees are looking for when picking a master trust provider. And what I've got on the next slide is those features on a high level. So I've got them categorized into 8 areas. Now, for example, as a trustee, you might want an investment default that's comparable to your current scheme. You might want a master trust that offers really strong governance policies. You might want a master trust that offers really competitive charges and better overall value for members. Now, identifying these wants early on the project, as well as having the agreement in principle from the bulk transfer, it does really make for a smoother asset transition later in the project. But there's lots and lots of features that sit behind all of these that trustees would want to get involved in. Now, moving on to the next slide, which is the wider considerations and the risks for a master trust project. So on here, we've got some of the common areas, and Hannah will take you through some of the legal points first, and then I'll pick out some further points to talk through as well.
Okay, thanks. So in the time that we've got today, we're not going to be able to go through all of the points on that slide that Shabnam's just shown you, nor are we going to have time to go through all the legal points, but we can definitely use the time today to talk about some of the issues which come up on pretty much every transaction, which we found can be, particularly time consuming and knotty. And so we think we've actually got quite a lot of good know-how to share with you, hopefully to share some experience and save you a little bit of time if you're starting to think about master trust transactions for your own schemes. So I've put them on the slide here. The first issue I just wanted to touch on is it's an employer side issue, and it's around current staff. And one of the first things that an employer is going to need to establish before it decides whether it's feasible to go ahead with a master trust transaction is whether they have any particular contractual issues with their existing staff and existing contracts which would prevent them or delay them in going ahead with a change of pension scheme provider. Now, employment contracts, anyone who's in HR will know, come in all shapes and sizes, and they're not just restricted to what's written down on a piece of paper which says employment contract at the top. They can also incorporate amendments that have been made over time, implied terms, and terms implied by customer practice. So actually working out what an employee's contractual benefits are can be quite tricky. In relation to a master trust transaction, we would always recommend that employers carry out a proportionate amount of due diligence into employment contracts. So, you wouldn't necessarily be able to get to the bottom of every single employee's contractual promises over the whole history of their employment. But as an employer, you would certainly be wanting to do a spot check of written employment contracts to work out whether there is any wording in those that would lead you to believe that you need to, for example, get employee consent to change provider. Red flags that you might be looking out for here are if, for example, you've got written contracts which say very clearly, you are entitled to join a named occupational pension scheme and build up benefits in that whilst you work for us, because that would, arguably give rise to a contractual right to stay in that scheme. And that might mean that you need to think about additional steps to go through before you can make that change without it being a breach of employment contracts. Linked to the employment contracts piece, employers also need to think about their duties under pensions legislation to consent with current employees about a change of pension scheme. Now, for anyone who's been through a DB, defined benefit closure exercise, pension consultation might put the fear into you, because those pension consultation exercises, in my experience, can be quite drawn out. They can be quite emotive in some cases and take quite a long time for employers to work through and manage. Fortunately, you're pleased to hear that in relation to changes of DC provider, in my experience, consultation is much less onerous for employers. The underlying legal duties are the same, but in practice, we're finding that the amount of employee engagement and feeling in relation to provider selection is probably less than it would be when you're talking about a change from DB to DC. And so consultations generally run pretty smoothly, but that doesn't mean that the employer won't want to take some time at the beginning to make sure that it sets the process up in the best way so that it can have meaningful consultation with its employees. And consultation can also be a good way to improve employee engagement with the idea of master trust and pension saving more generally. So that's what I wanted to say on current staff. In relation to existing DC pots, and this is coming back to the phase 2 of the two-stage process that I talked about a few slides ago, there are a number of legal points that can come up around the transfer of accrued pots into a master trust, both from a trustee and an employer perspective. These generally come up in due diligence, and the majority of the issues that we see in practice relate to provisions in either the existing schemes rules or in administration practice, which give rise to complications in how you transfer to a master trust. So one of the jobs that we would always do at the outset of these projects, and would recommend whether we're advising trustees or employers to get done, is to work through a checklist of known issues in relation to pension schemes, so you understand at a very early stage whether there are any issues that might slow down a master trust transaction or mean that you need to take steps before you get as far as transferring existing pots. So the kinds of issues that I've seen in practice, for example, would include DC schemes which have ordinary plain vanilla DC benefits for current staff, but they might provide a DB type benefit on death in service. So for example, if you have a set of scheme rules that say if a DC member dies whilst they're in employment, their spouse will get a pension, which is a multiple of the employee's salary. That's a DB benefit, and so it's unlikely that master trusts will replicate that. Master trusts either don't provide death benefits at all, in which case you need to look at a separate trust for death in service benefits, or if they do provide benefits, it's most often a multiple of salary as a lump sum rather than as an ongoing pension. So that's one issue which can come up. Other issues which come up, and I think Shabna's going to touch on this as well, are around tax protections. So that's again something that we would want to flush out at an early stage and understand whether it's an issue. And then the other one which can come up in particular if you have older occupational DC schemes is if they have any kind of DB underpin or contracting out underpin in relation to the benefits, which again can be difficult to replicate in a master trust. So as I said, the best way to work through those is to do some due diligence early on, understand what benefits you've got in the transferring scheme, and think about whether those are benefits that need to be either removed, replaced with an alternative, or whether that leaves you with populations of staff for whom a master trust transfer would not be appropriate. So that's in relation to existing DC pots. The final legal issue I just wanted to touch on is data protection. So this is something which again comes up typically on every transaction that I've advised on. In order to implement a bulk transfer from one pension scheme to another, those two pension schemes, transferring and receiving, typically need to share data about the members of the pension scheme, and that will usually be personal data, and in some cases it will be sensitive personal data because it might include information about people's health or their nominations for death benefits. So that means that you need to think about data protection law and whether it is legal and possible to share that data without the data subject's consent or some other protections in place. Now, when you come to look at bulk transfer agreements between a transferring and a receiving scheme, they do typically deal with data protection. So they will set out in a clause somewhere whether the parties are acting, typically the parties will be acting as a data controller to a data controller, and both agreeing that they will comply with their legal requirements because of that. And that's great, that's really helpful when you get to the point of actually transferring the assets over. What can be slightly trickier in practice is that often the transferring scheme and the receiving scheme will want to share member data before they get to the point of having signed the bulk transfer agreement. One of the reasons for that is that the receiving scheme might need to set up member accounts for the transferring members. And the other reason is that the receiving scheme and transferring scheme may need to do a cross-check of their membership in order to work out if they've got any individuals who are already members of the receiving scheme, because if that's the case, that can in some cases cause issues for tax protections. So all of that means potentially transferring trustees are being asked to share member data before they've got a bulk transfer agreement in place. And so one of the issues to work through from a legal perspective is whether that is okay under data protection law, whether the trustees would want to ask for a standalone data sharing agreement, or more likely whether they would want to take some interim steps to kind of satisfy themselves that data security measures are in place and that they've done a proper data protection audit, so that they're comfortable sharing the data without a standalone data sharing agreement. Okay, so those are some of the key legal points. I'll now pass back to Shabna to pick up on one or two others on that slide we saw previously.
Thanks, Anna. So I'll pick out on the slide, there's some bold ones there. So firstly, protected cash and retirement age. Now, this is where some members are entitled to tax-free cash higher than the usual 25% of their pension pot, or protected age where they're entitled to a minimum pension age that's earlier than the standard minimum pension age. And what we found is the tricky part is identifying these members. So there's some data cleanse work that's needed alongside with your administrator to work them out. Now, in most cases, once you've identified which members are effective, these protections can be carried forward to the new master trust. That's as long as the bulk transfer rules are met. Now, in some cases, the transfer rules aren't met, and that's usually in the case of a partial transfer, if a member has benefits elsewhere within the trust. So that's worth working through that at an early stage. It's also worth mentioning hybrid schemes here. So where you may have some members with both a DC and a DB benefit in the same trust, and your scheme allows your members to use their DC pot to fund their DB tax-free cash rights. Now, that's usually not an option going forward once a DC pot has been transferred to another trust or a master trust. But you can set up what we call a switchback facility. And this is where you transfer back the DC benefits at the point of retirement to the original DB trust scheme, and still therefore have this option to take the tax-free cash in this way. And it's quite a common facility now for master trust providers to offer this. Now, moving on to ongoing governance of the new master trust arrangement. Now, that's something to consider early on in the project. So whilst there's no requirement to set up a governance committee to oversee the new master trust, it is really part of good governance to really keep a close eye on your provider, especially as the market is changing quite rapidly. Now, in practice, what we're seeing, the level of oversight does range between employers. It ranges from limited oversight, maybe a once-a-year check in, to something a bit more in-depth oversight, maybe quarterly meetings with your provider. Now, what works really well with a master trust transition project is to establish that governance policy early on and communicate it with your trustees and their members, because it's a real positive message as part of the overall transition to a master trust, that you're not just simply transferring the members and forgetting them or abandoning your members. And finally, transition costs and out of market risk, which I'll cover together. So this is a cost of disinvesting and reinvesting from the current investment funds to the new investment funds with the master trust. And also there's a risk that the funds are out of the market for a short period of time. Now, this cost and risk would in normal circumstances be met from the members' pension pot. But providers, master trust providers, have recognised that that's quite a big hurdle to overcome for some of the trustees when it comes to approving that bulk transfer, that members might be out of pocket here. So commercially, the providers have taken that decision to meet the transition cost and mitigate those out of market risks on behalf of the members. And that's as part of the negotiation of terms when selecting a provider. So there's a few of the wider considerations and risks that I've picked out are quite common, but there is a lot more on here that we could cover, a lot wider things to think about. But what I will do now is just hand back to Jo to close off.
Great, thanks both. So I think that was hopefully a really useful summary of kind of the key points that you need to take into account when you're embarking on this kind of transaction. As both Hannah and Shabna have said, there's a huge amount to cover, and I think really, as they've emphasised, the key part is really in the planning at the start of the process to ensure that these transactions run smoothly. So we've now got about 10-15 minutes for the Q&A. So we've had a few questions through, but please do keep them coming. So just bear with me. So the first one, probably one for you, Shabna, if that's okay. So can you provide some examples of suggested lower cost charges of master trust, and what level of charges might be considered to be good? Can you hear me? Did you get that okay?
Yeah, that's great. Yeah, so typically what we've seen, the clients that I've worked with have moved to master trust. They've come from an average member charge of around 50 basis points or 0.50% per annum. And what we're seeing, typically we're moving those members to a total charges of around half of that, so around 25 basis points. And that is really competitive in the market. It's overall, if you think about what members are getting more in terms of that master trust, they're getting better tools, better communications, a better overall service, a well-governed arrangement as well. So around 25 basis points is what I would say is really competitive. Now, we know that master trust providers quote terms on a bespoke basis. They don't have standard terms. So that typically the larger schemes, larger assets under management, more contributions going in on a monthly basis, those are more attractive to a master trust So they will give you better terms, more competitive terms compared to the smaller schemes. But but it is very much bespoke to the size, the nature of the scheme, the sector, and the characteristics of that scheme.
Okay, that's really helpful. Thanks, Shabna. And now one sort of on the legal side, just really picking up on something that Hannah mentioned, and Shabna, you did too, but just around special tax protections. I suppose, Hannah, we do see a lot of knotty issues crop up. I was just wondering whether you've had many projects where those types of protections that members have actually stopped the project from proceeding as planned, really, and how you've dealt with it.
Yeah, that's a good question, Jo. So I have never yet seen a master trust transaction which has not gone ahead at all because of concerns about members with tax protections. What I have seen in practice is on transactions where that due diligence hasn't been done early enough that this issue can come out of the woodwork later on in the day, and it can cause a delay because it takes a little while to work through asking the questions that you need to ask in order to understand, firstly, whether the transferring scheme has got members with special tax protections or special benefits. And then secondly, understanding whether that is a complete blocker to transferring those members or whether other things can be done in practice. I would say the biggest issues tend to arise in relation to hybrid schemes, because for most of the special kinds of tax protection that we're talking about here, so that is things like protected tax-free cash or protected pension age, those protections are lost if you make a transfer, which is not something called a block transfer under the legislation. And if you have a hybrid scheme where the same member might have benefits in both the DB and the DC section, but you're only transferring the DC section benefits, that's when the block transfer condition is potentially not met for those members, and that's when tax protections could be lost. And if that comes up, then you get into all sorts of questions about understanding whether those tax protections actually do arise, or is it just a hypothetical possibility? What might the impact of losing that protection look like for members? And is there any way that those tax protections can be preserved through, I think, Shabna, you called it the switchback mechanism, where the member might be able to transfer back into their existing scheme at the point of retirement. And that does sort of partially reinstate some kinds of tax protection, particularly protected pension age. I don't think it's a complete fix for protected tax-free cash. But like I said, the main issue in practice is understanding whether those issues are going to come out of the woodwork early on. You don't want to be dealing with them 2 weeks before a transfer when you haven't got the time to sort it out.
Yeah, no, exactly. I completely agree. And just linked to something that Shabna said in her presentation around the switchback mechanism. Are you seeing, Shabna, most of the large providers offering that now?
That's right. It's very common across the providers. It is very simple to administer. It is just for them, their perspective, it is just a transfer out, and it's just making sure that they communicate with the members at the point of retirement that that option is there. So it's all set up, it's all communicated really well. It's well received by trustees when they're trying to approve the bulk transfer. It's quite an important point for trustees as part of their consideration, so it does really help with that decision making process, but it's very, very common now.
Yeah, great, that's helpful. And apologies, I've just turned my camera off. I was getting some slight interference, so hopefully you can all still hear me okay. So another question for you, Shabna, that's kind of linked to a comment I think you made at the start of your presentation, that you're still seeing certainly some of the larger single employer trusts not actually at this point in time to decide to transfer to master trusts. So the question is, will single employer schemes depend on larger employers or employers having better schemes than any consolidator? So is it size that might stop the transfer happening, or is it because the employer is comfortable that their scheme provides everything that the member needs?
Yeah, they're closely linked, those 2 points there. And that's where my conclusion came from, that it's those larger schemes that are able to offer better, that have assessed what their members need and can offer better value or better overall service to their members versus a larger master trust, for example. And where I talk about better, where they can distinguish themselves from a master trust, is where it's a bit more personalised. Yeah. So a master trust solution is quite a standard solution. But a single employer trust, there's a lot more flexibility to personalize the communications, personalize the investment default solution specifically for those members. Now, if considering all of those areas, an employer feels that they can offer something that's better value than the master trust, they're the ones that I believe will stay as a single employer trust arrangement versus some of the others. But we are seeing some really large employers move to master trust. The master trusts are really proving that they can handle those larger master trusts. They can still personalise to a certain extent and still be cost effective and offer value for members. So there's a different perspectives there. It does need a lot closer look at from the regulators, that they're only targeting some of the smaller employers at the moment, but they need to also look at some of the bigger ones.
Yeah, I think that's right. And I think one of the things that certainly in the projects we're involved with is that one of the things that can be quite attractive for master trusts is again something else you mentioned, Shabna, that they kind of look after members throughout the whole journey, not just kind of when they're saving, but also the decumulation phase. So obviously a lot of single employer trust clients don't provide those more flexible options at retirement, which master trusts, because of how they're set up, they're set up to do that. So that seems to be something that's quite attractive as well, I think, for employers moving to master trusts. So question for Hannah now. I know that Shabna said that, you know, a certain master trust will still offer bespoke options depending on the size of the employer. Just be interested in your views on some of the legal documentation and whether you're seeing a move to kind of a more standardised approach, or whether trustees are able to have any kind of negotiation power there, I guess.
Yeah, definitely. I would say that when master trusts were quite new, it was quite easy to negotiate a bulk transfer deed, partly because I guess all of the master trusts were also learning through negotiation about how to refine their standard form bulk transfer deed. I would say that generally it is getting much more difficult to negotiate bulk transfer deeds to such a degree. I think there are key terms where obviously they will be commercial points that there will be some room for discussion on. But we're increasingly seeing a streamlined process for actually negotiating bulk transfer deeds. Similarly, I think we've also had the benefit of seeing most of the providers transfer deeds as well, and there's a lot of kind of not standardization. They obviously all do have their own terms, but there are common features to all of those deeds that have come about through collective experience. And so I think that's also a good thing for clients who are looking to get into master trust, because it means the transaction is probably less onerous in terms of the legal negotiation of that transfer deed than it would have been had you done this 2 years ago when you were something of a trailblazer for that set of terms. So I think there are probably some cost savings for clients there as well.
Yeah, I think so. And I suppose, you know, if you're embarking on this kind of transaction and there are any particular areas that the trustees or employer are concerned about, it's probably helpful to have sight of those legal documents as soon as you can, just in case you want to take those into account as any part of the commercial negotiations as well, rather than getting them once you've almost signed on the dotted line, so to speak. So another question for Shabna. And one of the things that I think is really interesting on the sort of your slide where you were looking forward to 10 years to see what the market might look like, and certainly we're starting to see, certainly as a result of authorisation, some master trusts just winding up, or others that are now consolidating with each other. So how do you manage the risk of a master trust consolidating with each other when you're embarking on this kind of project, when you've been through a whole feasibility exercise, your members think they're with a particular provider, and then 6 months down the line, actually those two master trusts, or that master trust is combining with another one? Just be interested in your views on that.
Yeah, no worries. That's certainly a hot topic at the moment. It's certainly something that clients are worried about, and the key bit around managing that risk is knowing about the potential consolidation.
Yeah.
Which is if you had a crystal ball, that'd be great. You'd be able to work them all out. But really, in reality, knowing about the consolidation is through the strong relationships that we, for example, as a third-party evaluator, have with the providers and our knowledge of the market. So where we're seeing consolidation happen, and it is happening at the moment, is with providers at the smaller end of the market, so smaller in terms of assets under management, or where there are some providers where there's some synergies between the two providers.
Yeah.
They might be on the same investment platform or the same administrator, so that makes it quite straightforward for them to consolidate. Now, it's with our close relationships that we have with those providers, we are party to some of those early conversations between providers that are consolidating. So that really helps. Just knowing about it, knowing it's coming around the corner, really helps with managing that risk. The other point is around the contractual negotiations we were talking about earlier. So when it comes to selecting a provider, it's important to look at the exit terms. And some of those can be negotiated. So it's important to ensure that the if a consolidation situation happened with your providers, make sure that those terms and conditions are written into those exit terms that you have in place. That's really important. So those, I would say, are the two key areas, two things two tips that I would say to have in place when you're worried about consolidation of providers.
Great, thanks. That's really helpful, and I think that's sort of one factor to take into account. I know Hannah was talking about legal factors or the kind of considerations trustees need to take into account, and we've just had a question which comes up quite a lot on these types of transactions actually. So where the investment charges in a master trust are more expensive, is it reasonable for trustees to trade off or justify having higher charges in a master trust because it provides better member, online access to modelling tools, etc.? So Hannah, I wonder if you might take that one, and Shabna, if you've got anything to add, feel free.
Yeah, I mean, I think the answer has got to be potentially yes, because trustees, there's 2 points on that. Firstly, the trustees of the existing scheme will generally have the power to switch investment platform and provider, and they could in fact make the decision to move members onto something which is more expensive, but they think higher quality and likely to lead to better member outcomes. And so, that should also be possible through a master trust transfer. And secondly, it's coming back to what I said in the presentation, that in my view, trustees don't need to get comfortable that every single aspect of the master trust is better or the same as what they've currently got. They can look at it holistically. So you can look at the benefits to members that come from a master trust, which may not be the bottom line cost of it. I would say it's one that needs to be treated with a bit of caution, though, because it can be quite an emotive one for members, and the bottom line cost is one of the key things that members will look at in terms of, so you need to probably work quite hard on the comms to convince members that they are getting those benefits that you think are worthwhile paying for. So that's
it's always easy to measure costs, isn't it? I think
exactly.
It's very tangible. So.
Yeah.
Okay, and then final question. I'm conscious of time. We're at 11:42. So question out there which Shabna or Hannah feel free to answer. Do you have experience of schemes offering winding up lump sums when moving from own trust to master trust? And how might that affect current employees joining the master trust, if at all?
So yes, I've seen it done. I think I'm right in saying that you can only offer walls if the transferring scheme is a pure DC scheme rather than part of a hybrid scheme, because in order to be able to offer walls, you have to be winding up the whole scheme. So that's one thing to look at the outset. I think it would also affect your overall timetable, because if you're making a walls offer, you need to give members longer to think about it. Whereas if you're doing a straightforward bulk transfer without consent, you just need to give them a month's advance notice. I think walls is more like a 3-month notice period to make those decisions, so it affects your timing. And I suppose that might have a knock-on impact on new people coming into the scheme and the date for your kind of go live for active employees.
Shabna, was there anything you wanted to add? I think Hannah covered that in quite a lot of detail.
Yeah, she did. I totally agree that it's not common to offer walls as part of a master trust transition project. And that's probably typically because of the timing, and there's an extra cost involved in terms of communicating around this as well, whereas the other option is just to move everyone to a master trust. The other piece around that these benefits are there to provide a retirement benefit, rather than give the amount of the cash to the member at an earlier stage. So it's balancing all of those needs and objectives and what it is that you're trying to achieve with the project, then really dictates what decision you make about whether to offer the walls or not. It is much more simpler to wind up the trust if you don't offer the walls and just move everyone out. Then you've just got an empty shell to wind up.
Great, thank you very much. That was really helpful. Right, I'm conscious of time. With a minute to go, I just leaves me to say thank you very much for attending today. We hope you find it interesting and useful, and thanks very much again to our speakers. Once you log off the webinar, there will be a feedback form, and as I said, it would be really great if you could take 30 seconds or so to complete that for us. We really do value your feedback, and there'll also be a recording made available after the event, which we will share with you all. Thanks very much, everyone, and hope to see you all soon. Thanks.